Professor BT Kaul Sahab, I welcome you to this session of Nurturing Smart Teachers. Your profile, your contribution as a law academic, as a practitioner, as a teacher is known to everyone who's connected with law teaching in India or even otherwise. I welcome you, and as far as interpretation of statute is concerned, I would start part one of this video by seeking your views with regard to significance and utility as to why this interpretation of statute has been included in the law curriculum.
I think any law curriculum without this subject will not subserve the purpose of legal education, especially when we have to produce quality lawyers, quality judges, and they should not only be able to compete at the national level, but should become part of the global legal profession or legal judiciary, whatever you like to call it. You see, every legislation which is made, even if it is made with the best of skills of a draftsman, there are bound to be issues that will come up for interpretation, whether these are matters relating to the factual issue or legal issue, and sometimes very important constitutional issues. Now, I think the law is what the judges say.
Quite right.
Therefore, the interpretation of the statute or statutes is something which is very, very important as a curriculum. And in fact, when a student is introduced to the subject of the law from the very first term, one or the other subject is given to him for study, and that is taught in the classroom through statutes and judicial decisions. So therefore, a scientific methodology of studying a statute and the judicial decision-making process, he must understand. And this must be done as a subject itself. That is why earlier it used to be an optional subject. I personally feel this should be one of the compulsory subjects taught in the LLB curriculum, because it is the foundation for becoming a good lawyer and a good judge.
Very well brought out. Now, also connected to this, a question that how is the teaching of interpretation different than, say, instructing in other courses, say criminal law or constitution or environmental law? How is the teaching of interpretation different?
I think teaching of interpretation is different in the sense that what is the new method, in fact, approach to the legal teaching, they say 10 plus 2 plus 5 is the new mode of legal education. Is primarily because the students must not only be inducted into the law courses, but they should be taught various interdisciplinary subjects which have great bearing upon understanding legislation and the judicial process. That is why psychology, economics, political science, literature, because when we have to interpret a statute, we must know the social context of the legislation. So therefore, when we teach this subject, a student, a teacher must be ready to read more than what is in the statute or what is in the law books. He has to have a perspective of the society. He has to have the perspective of the economics of that state. And therefore, when we go to find the text law, interpret the text law, we must know the text policy. When we know penology, penal law, we must know the changing philosophy of the criminal law. So therefore, when we were dealing with retribution, now we are on reformation. So therefore, there's a sea change that has taken place. So the student, teacher must be aware. And I think one of the most important things for teaching this subject is a teacher must have thirst for knowledge.
Thirst for knowledge, yeah. Very well put in.
And he must be a good reader. He must study judicial decisions, prolific reader of judicial decisions.
Okay.
Because ultimately, when you teach this subject, you teach it through judicial decisions only. Because there are two kinds of areas. One is occupied area.
Yes.
Second is unoccupied area. Now, unoccupied areas are those areas where the legislation exists.
Yes.
Unoccupied areas are those areas where there is no legislation. And you will find the common law has much to contribute in the areas where there was no occupied legislations. So therefore, a law teacher must be a prolific reader. He must have thirst for knowledge and must not stop with the subject that he thinks he has specialized. He must be ready to read other subjects as well also.
That's what it sets apart from other subjects. Now, in interpretation, there is a hierarchy of rules that are used. And keeping that in mind, why is it that the literal rule is often called the primary rule of interpretation?
There is no hierarchy of rules.
Okay.
There is only one rule which we call as the primary rule of construction of statute is called the literal rule, or what we call as ordinary rule of construction of statutes.
So this is very important.
Very important. There is no hierarchy of rule. It's a pick and choose method that judges have resorted to in case-to-case basis. I do not say that they do not follow a particular pattern, but I say there is no hierarchy. But one rule they cannot discard. That is the rule of primary rule of construction of statutes. But if you read some of the very outstanding judgments of the Supreme Court, I think I remember one of my very well-known cases which I always talk to my students is RMDC versus Union of India, where the majority judgment said, where the Supreme Court said that literal rule has prima facie preference. But to arrive at the true intent of the legislature, the courts can resort to other rules of construction of statutes, primarily mischief rule of construction of statutes. And in fact, it is a case where the court arrived at the same conclusion by applying the primary rule of construction of statutes as well as by applying the mischief rule of construction of statutes.
Now, there are two aspects that come to the mind. One is the legislative intent, and then there is object of the legislation.
I think this is where the teacher has to be very, very thorough.
Yes.
You see,
are the two
yes, no, they are not synonymous. In fact, when I talk to you about text and context, object of the statute is the context, whereas the intent has to be found from the text of the statute. So the words in the statute have to take color from the context. So object of the statute, there is a lot of literature available to you, a lot of material available to you. You can go outside the statute, read the historical background of the legislation. You can go to the expert committees. You can go to the debates on the floor of the House. But when you come to find the legislative intent, because the intent has to be found from the words used in the statute. So sometimes when we look at the statute, we say statute is divided into two parts. One is operative part of the statute. Second is other parts of the statute. Now that is what we call as internal aids. Preamble, long title, headings, marginal notes, explanations, illustrations, schedules. These are all internal aids. Internal aids are to subserve but not to replace the operative part of the statute. So therefore, one of the arguments that was raised in one of the cases was, head can wag the tail, tail cannot wag the head. So internal aids cannot wag the head, head can wag the tail. So therefore, very important aspect that a teacher has to keep in mind. Object of the statute, you can go outside the statute.
As you said that there is plethora of
literature you can consult. Material that you can consult. But when it comes to the finding the legislative intent, this can form the canvas, wider canvas. But intent has to be found within the statute.
Now, while teaching interpretation, one of the option can be for the teacher to rely primarily on the legislative intent with regard to that particular enactment. Would you say that he should also, where required, traverse beyond the statute?
You see, language is the best vehicle of communication,
Yes.
but it's not easy to have plain words used in the statute. How plain is the plain language of the statute? One cannot answer
Yes.
this question. It's a very, very
May
difficult
differ from
question.
case to case.
Yes. No, it is a statute to statute. That's why these days we find that there's not a lot of time devoted in enacting a statute. There must be a lot of time and lot of skill required in drafting, because when you draft a statute, you have to keep in mind all these rules of interpretation of statutes. So therefore, when you are drafting a bill, it has to be done by the experts who are very well conversant with the rules of interpretation of statutes, significance of internal aids, significance of external aids. And they must draft the statute in such a way that as far as possible, the statute makes a plain reading. But it is not easy because there are two rules of interpretation of statutes which are as important as the literal rule. One is that the statute must be read as a whole.
Yes.
You cannot read a statute in isolation.
Or in part.
It is only when you read the statute as a whole, then you make quite a good idea about what the purpose of the legislation is, what the legislative intent is. And there are sometimes, we say casus omissus. There may be certain omissions which may be deliberate omissions. But there are, in the process of drafting a statute, what we call as inadvertent omissions. Now, those can be supplied by the courts. Now, what is advertent, what is inadvertent omission is a very, very difficult subject for the courts to decide. But once it comes to the conclusion that it is an inadvertent omission, courts can supply. Because we say in the separation of powers, it is the legislature which is the primary duty of lawmaking, and the judiciary has only the role of interpreting the statute. But it is not easy to say that the judges do not make law. I think it's, as I said in the beginning, they infuse life and blood, flush into the statute, and that's why some judges, some judgments of the judges remain locus classicus, and some are only books of the time only. So you read them once and don't read them again. But there are judgments we read, reread, and reread. Like, I was talking to you about RMDC's case.
Yes.
It was Palkiwala versus Sirvai. And you will see in the course of this case, at some point of time, Mr. Sirvai conceding that yes, the language of the statute is not plain, it is void. But then he says, looking at the legislative history of this Betting and Gambling Act, which was the subject matter of the state, but has been enacted on the request of various states by they passed a resolution under Article 252, and they requested the Parliament to make a law. If you look it in that, the purpose was only to cover betting and gambling, not the activities which involved labor and skill.
In fact, that's one of the earliest cases
where
Nani Palkhiwala had appeared and shot into prominence thereafter.
Yes.
And the difficulty in this, not in this, but in interpretation is that one, as you said, that lawmakers need to be well versed in the process of lawmaking, but Parliament at times they do not have the time which you said time is required.
It's very required.
The second problem is that some situations when you relate
like
it to
if you
cannot be foreseen.
Let us look at the 2013 amendment to the IPC.
Yes.
On the basis of the Verma committee report. I think one of the most hastiest amendment that was brought, and it has created more problems than it has solved. So that is not, especially when you are dealing with the text and the penal statutes, you have to be extra cautious because it is the liberty of the person which is involved if he is to be penalized.
Very strictly and technically to be construed.
But sometimes we find, by applying the mischief rule, like we have Sudra Devi's case in tax law, the Supreme Court majority narrowed it, but minority widened it. applied the mischief rule of construction of statutes, whether an individual included, female SSC, or it included only the children. That's whether it included the wife or it included only the children of the SSC, earlier SSC. So these questions are very, very important.
Now, very often the two widely used terms are the internal aids and external aids in interpretation. And what importance have the constitutional courts in India accorded to these two?
You see, we must understand, when I said a statute can be broadly divided into two parts. One is operative part of the statute, which we call as enactment.
Yes.
And there are other parts of the statute. Not that they are not part of the statute. They are part of the statute. They have been passed by the parliament or the legislature, whichever is the competent legislature which has passed it. But what is more important is that you have to first find intent from the operative part of the statute. Don't go to the other parts of the statutes if the operative part of the statute is plain and clear. It is only when there is an ambiguity, it's capable of more than one construction.
Yes.
Then, we go to the other parts of the statute. Like preamble, we say, is the key to open the mind of the legislature, why of the legislation. Long title, we say, is the what of the legislation, that is the subject matter it deals with. I'll give you one illustration. Punjab Shops and Establishments Act is a constitutional bench judgment of the Supreme Court, which came Manohar Lal versus State of Punjab.
Yes.
Question was, there was an operative part of the statute. It says every shop and establishment shall observe a close day. Every shop and establishment shall observe a close day. The preamble to the act said, an act to provide for working conditions of the employees employed in shops and establishment and regulate their working conditions. Employees.
Yes.
Now, there was this gentleman who had a shop which he was carrying business along with his family members and had no employee. So he said, look at the preamble and read this operative part of the statute. It says shop and establishment must be read as shop and establishment employing employees. I have no employees, therefore I don't have to keep it closed. Court said operative part of the statute is plain, clear. So therefore we will not go to the preamble. Every shop and establishment means every shop and establishment, whether with or without employees. So now you see the significance. If the language is plain, you don't have to go to the operative part of the statute. And then the court went to explain. He said, not only the employees should get a rest day, even a person who is running the shop is a member of the society. He must be in a healthy condition. Therefore, he should also observe a close day. So one of the illustrations to show you